Good morning, everyone. It's morning for me here. I'm not sure what time or date it is for everyone listening, but welcome nonetheless. My name is Derek Frenette. I'm an associate at Alexander Holburn, Bowden & Lang, as you can see on the screen there. And I practice in a few different areas of the law, but one of the areas I practice in is trademark prosecutions, which is the registration of trademarks with the Canadian Intellectual Property Office, and litigation around intellectual property matters involving trademarks, copyright, etc. So today the theme or the topic I'll be covering is branding and trademarks. And as you see there, this is of course brought to you by Philanthropy Partners, as you well know. And they've asked us to give this presentation to their partner organizations and give a bit of information about branding and trademarks. So the focus of this presentation will be on the basics. The field of trademark and intellectual property law is broad and deep. There is a lot that you could pack into a presentation on trademarks, but I've tried to keep things today to the introductory level and to cover really the essential bases for understanding what a trademark is, how you go about considering whether to register a trademark, what a trademark looks like, what it might be, how the process works, and then some issues around enforcement, etc. So just advance the slide here. As you'll see, our little friend there, the circle R, and I'll discuss R and TM and the little superscript trademark identifiers in a bit, but this slide really is about what exactly comprises a trademark and how the legal framework in Canada is set up for trademarks. Trademarks are a form of intellectual property. The other forms are patents, copyright, trade secrets, industrial designs. Those are the big four. There are some other forms that I won't mention, but those are really the big four, and all four of those are the jurisdiction falls within the federal government. So the provinces don't have lawmaking authority with regard to intellectual property. It's the federal government that does so, the Parliament of Canada. And that makes sense when you think about it, simply because these forms of property are really cross-border. So when we'll discuss the scope of a trademark in a bit, excuse me, registration is federal. So you register with the Canadian Intellectual Property Office in Ottawa. It's a single government office that is part of Industry Canada, and they administer trademarks, patents, industrial designs, and so on for the entire country. So with regard to trademarks, they are governed by a piece of federal legislation called the Trademarks Act. There are regulations under the Act, and then there are policies or guidelines that the registrar of trademarks, who is the person established under the Trademarks Act, the person or the office that's in charge of trademarks, makes those policies and administers the system and the database, the register, so to speak, of trademarks. So what is a trademark? A trademark is any word, logo, sound, and that can include possibly a taste and smell as well, which identifies to consumers the source of a product or service. So when we look at the origin of trademarks in Western societies, it really stems back to England and the identifying marks that were placed on goods for sale. So in those days, it was necessary to identify one's wares, the manufacturer of the wares, and they might have received a royal commission to produce and sell those wares in the kingdom. And a trademark was a way to identify those as genuine and to identify the source of those goods. So that still is true today. And these various forms of trademark, and let's use a well-known example. Let's say the Coca-Cola Company might be a good example for us. A word, they would have a family of trademarks, one of which is the word Coca-Cola. A logo, which is, likely their little swoosh, the wording Coca-Cola in script, and then a little wavy kind of white line mark. Sound, you'll notice in Coca-Cola commercials that they have often the sound of a pop can or a pop bottle opening and escaping gas, fizzing. That could be trademarked possibly. And then taste and smell. We'll get to the idea of trademarking the taste of cola or the smell of cola and how that might be a problem in a bit. But suffice it to say, for this example, we have all sorts of trademarks, and any of those with regard to the Coca-Cola Company could be trademarked and are trademarked. So then we move to the legislation and we consider what is registrable. That is, what is possible. When we look at the legislation and we take these forms of trademarks and say, well, what can we register? And Section 12.1 is the section that covers what is registrable. So if we look at the section, it is worded in the negative. Trademark is registrable if it is not. And we have a number of things set out here. Number one, a word that is primarily merely the name or the surname of an individual who is living or has died within the preceding 30 years. So that means you can't trademark someone else's name for obvious reasons. There are problems with an individual trademarking their own name. That section covers that off, and there are some ways to get around that, but obviously, you can't trademark someone's name who's currently living or has died within 30 years. Then B, it's quite a big mouthful, but whether depicted, written, or sounded, either clearly descriptive or deceptively misdescriptive in the English or French language of the character or quality of the wares or services. And there's a lot packed into that section, but what it boils down to is essentially that a trademark cannot clearly describe the goods and or the services that it's registered in connection with. So if we use the example of, let's say, pet food, I can't register the name or the trademark dog food in connection with dog food. And the reason I can't do so is because those words or that trademark is should be, it's a matter of public policy, left for all traders. So if I'm the Purina company and I trademark dog food, and then anytime someone wants to put the wording dog food on their packaging in that industry, I send them a nasty cease and desist letter and say, I own the trademark dog food. You cannot use the words dog food in connection with your dog food. Stop immediately or I'll sue you. You can see how very quickly the situation becomes ridiculous. So in the interest of public policy, in the interest of free and open trade, the policy decision was made, and this is true in most countries in the world. I'm not aware of any jurisdictions where it's not the case, that clearly descriptive terms describing wares or services are out of bounds. So things like dog food, or things like jewelry, or things like burgers and fries. It would be difficult to trademark any of those in connection with those wares that you're selling. Carpet cleaning, or kiteboarding, or any number you can imagine of services that you would offer are the same. You can't trademark those words in connection with the services they describe. Now, if we broaden that and we consider dog food again and say that example and take clothing and wears like clothing, for instance, and we say, I want to trademark the term dog food in connection with clothing. Well, that's a whole different ball game, and it's likely fine, as long as there isn't another mark out there, and we'll discuss that in a second, and I'm not running afoul of any other rules under the Act or the regulations. It's likely fine for me to trademark the name dog food in connection with clothing, or jams and jellies, or carpet cleaning, or any other number of things that you can imagine where that brand or that trademark is not describing or deceptively misdescribing the wares or services in the application or in the registration. And that one comes up a lot. When folks want to register a trademark, they often want to register something that is obvious, that it is descriptive of their wares and services, because that's the way they advertise themselves to the public, and that's likely as true for nonprofit organizations as it is true for private enterprise. But they often run into problems, and at the registration or pre-application stage, we'll often identify to them, you might run into some problems here. There are ways to get around that, but typically that is a roadblock that you might face if you're trying to register a straightforward trademark that describes your wares or services. Moving to C, we have the name in any language of any of the wares or services, and so that's just kind of a related point. So you can't, dog food can't be dog food. And then we get to D, and this is probably the most common objection that is raised to a registration or an application. And it's the one that's typically of most concern to applicants such as yourselves if you're considering registering a trademark. And that is that the trademark is confusing, and that's a big term with a legal definition, with a registered trademark. So back to my dog food example, if I'm looking to register a trademark called dog food, or the trademark dog food, and I want to do so in connection with my clothing business, I'm fine under B and C here. That doesn't describe the clothing that I'm selling. However, if there's someone else out there who has trademarked the words dog food and they're selling clothing, a problem of confusion arises. So the entire trademark system, as we go back to the origins of trademarks in the purpose of them, which is to identify the source of wares or services, the whole system is predicated on exclusive use. That is, once you register a trademark, you are the sole party, the owner is the sole party that is entitled to use that trademark in connection with the goods and services that are in the registration. So if someone else has dog food, they're selling clothing branded dog food, and I come along and say, well, I want dog food and I'm going to sell clothing using that trademark as well, we can quickly see that the system would break down and trademarks would be virtually useless. So in the newspapers, when you see that PepsiCo or McDonald's or Mac, Apple, whoever, these big players are suing, sending cease and desist letters saying you're infringing on our brand and our trademarks, stop immediately or we'll sue you, and in many cases they do sue, that is to protect their brand, their trademark, and to enforce their exclusive right to use those marks or that trademark. So confusion really breaks down, and it's a little bit beyond the scope of today's presentation. Confusion breaks down to 5 or 6 factors, and those include the degree of similarity between the 2 trademarks, the channels of trade that the people or the parties are engaged in, how long the parties have been using the marks, etc. And suffice it for today's presentation to say that it is not possible for an applicant to register a trademark in connection with a mark or services and wares where there's already a mark out there that is the same or that is similar to the mark they want to register. Finally, we have E, a mark of which the adoption is prohibited by Section 9 or 10, and that really breaks down to trademarks that are prohibited because there is already a mark out there which has been registered by a government entity or an official entity within Canada. That can be local government, federal government, universities, certain public bodies. Once they put out there that they have a mark, often called a prohibited mark or an official mark, it's impossible to register a mark that is confusingly similar. So let's say we want to register a mark that's, Canada dog food, and I want to have a big maple leaf there. It's likely that the government of Canada is going to have something to say about that, or the Trademarks Office is going to have something to say about that, given that the federal government has a number of marks out there with the maple leaf, with the Canadian flag, etc., and the Act prohibits me from registering that trademark. So if you're fine on all those counts, that is your trademark, your proposed trademark, let's say again my example of dog food, I don't have any maple leaf logos on there, I'm not passing myself off as the Queen of England, I'm not confusing with any other clothing brands called dog food out there, and my mark doesn't describe, isn't someone's name and doesn't describe my wares or services, I'm good to go, and I would make an application to the Canadian Intellectual Property Office, which, as I said, is an office within Industry Canada, and say, hey, Property Office, I would like to register the trademark dog food. Here are the wares and services in connection with which I'm going to register, and please let me know, here's my fee, and let me know as the application progresses. There are two hurdles, basic hurdles you must clear to register a trademark. The first is you must satisfy the office, that is the government office, that Section 12.1 before you hear all these grounds are met. And number two, once they're happy, they publish it in what's called the Trademarks Journal. Everyone sees that. It's a public document. And anyone who has a mark out there can oppose for any reason if they feel that your mark is infringing on theirs, is confusingly similar, etc. So let's talk about rights. We have registration and we have common law rights. And this is where we get into the little superscript marks, the TM mark and the R mark. So a registered trademark is the strongest form of trademark in Canada. It's national only. So every country has its own trademarks office, has its own trademarks regime, and it's necessary to register if you're going to use your trademark. So I'm going to go out there and use my dog food clothing mark in any country in the world. I'm going to have to register in each of those countries to protect my intellectual property in those jurisdictions. In Canada, we are a use jurisdiction, which means that trademark rights arise on use rather than application or registration. There are certain jurisdictions where that's not the case. So in my case, dog food, I've got my clothing brand out there. I can apply on an intent to use basis, saying, hey, I haven't used this mark yet, Intellectual Property Office, but I plan to do so. And I am going to use this mark shortly. I'm applying to you now. I'm letting you know that I want registration. The registration of the trademark and the final finalized version of the trademark cannot be registered until I've actually used the trademark. And that use is a legal term. And it means in the case of goods or wares that I've sold goods or wares bearing the mark, either on the goods themselves or on the packaging. And in the case of services that I've publicized, I've advertised my services or offered them with the mark, so in connection with the mark. So with regard to my dog food clothing brand, I would have sold sweatshirts, jogging pants, shoes, whatever it is, with the word dog food or my logo, if that's what I'm going to use, as a trademark on them, or I could have used it on the packaging in which I sold the goods. That would qualify for use. But until I have a single sale, that's really not going to be possible. I'm not going to be able to register the mark. I'm not going to be able to finalize the process. Now, in connection with services, which is probably more interesting to you folks, seeing as you're primarily service providers, I think, the offering or advertising of your services or the performance of your services in connection with the mark is what's important. Oftentimes a website will be enough. So you have your website up there, you're saying, we are this organization, we're a nonprofit, we're promoting positive social change in this way. Here's our website, here's our name, our logo, etc. This is what we do. That is sufficient typically for showing that you've used, in the legal sense, your trademark in association with your services. Now, the question arises, oftentimes, if you're not using a website, how are you using? Well, if you perform the services and you have done so with letterhead or business cards or circulars, or you have posters or a vehicle wrapped with the logo or name or what have you, there are many ways to show use with your services. But until such time as you use, you cannot register. And that's proved in the form of a statutory declaration where, you know, an officer or a director of your organization would sign off saying, we have used and we're signing here, we swear that we've done so. And once that's happened, you can finish registration. Now, on registration, that's when you can use a little R. So you've got your name up there, you have the little R circle, and you can say, well, we have a registered trademark, this is us. So in the case of my business where, let's say we change the example a bit and I'm calling myself, DF, I'll just use my initials, social services, I've registered that in connection with services that I'm offering to affect positive social change. I go ahead and sign off and say, okay, I've offered those services, I've used them, I've provided services and advertised them, etc. It gets registered, and then I can use DF Social Services with my little R superscript to indicate I have a registered trademark there. Now, that's good for all of Canada. I can enforce my right to the exclusive services that I've registered in connection, or the wares in connection with that name. Throughout Canada, I can stop others from using it, and I can use the mark with a little R. Let's say for whatever reason that I'm not able to register that. Let's say that I've done business in my field of social services and improving the lives of Canadians for 5 years, and I've done so saying Derek Frenette Social Services. Now that might run into a problem in the sense that it's my name, and let's say the Trademarks Office objects to my registration of that mark based on the fact that it's comprised in part of my name. In that case, I can, without registering a trademark, still use that mark and go ahead calling myself Derek Frenette Social Services. In much the same way that likely many of you do without trademarks presently, and thousands of businesses across Canada do business every day without a registered trademark. So a common misconception that folks have when they're coming to register a trademark is they're saying, do I have to wait until I register? Do I have to apply before I can use this and sell goods or services using the mark? And the answer is no. You can go ahead and never have a registered trademark and do business all you like, but you don't have the same strength in terms of your rights as you do if you have a registered trademark. So we're talking there about the second bullet point here, which is common law, or the third bullet point rather, which is common law trademarks. So common law trademarks are unregistered trademarks, simply put. So I've been doing my 5 years of providing benefits to Canadians, improving their lives, and I just call myself Derek Frenette Social Services. I have a van wrapped with that. I have my letterhead. I have a website. I have TV commercials, what have you. And instead of the R, I can use the little TM with a circle around it. I don't need to do so. I don't need to use the R either, but the TM with a circle around it is evidence that I consider that my trademark, I intend it to be used as a trademark, and I'm putting it out there as a trademark. However, it's also saying I don't have a registration for this trademark. It is a common law trademark. The difference between a registered trademark and a common law trademark, there are many. A registered trademark is stronger. It's for all of Canada. You can enforce your exclusive right to wares and services that appear in the application in the registration. A common law trademark is not the same. It's restricted to the geographical area where you have actually used it. So to use my example of Derek Frenette Social Services, I'm going to be restricted to the Greater Vancouver area, let's say, if that's where I've used my trademark during that 5-year period. Let's say someone else, there's another Derek Frenette, and there are a few of us. There's a hockey player with that name. There's a comedian with that name in Quebec. Let's say they also have an organization called Derek Frenette Social Services, and they start business in Quebec or in Newfoundland or wherever. If I had a registered trademark, I could send them a letter and say, hold on a second, I have this trademark, you're infringing, but if I only have a common law trademark, unless someone's opening up in an area that I service and in which I've built a reputation and a brand, so to speak, I'm not going to be able to stop them in Newfoundland. So in that way, you have businesses in Newfoundland called Terry's Carpet Cleaning. You might have a Vancouver business called Terry's Carpet Cleaning. There can be 100 of them across the country. If none of them have a problem with that, if none of them have a registered trademark, and if none of them try to enforce their exclusive right against the others, they can carry on doing business consecutively at the same time. So something you want to consider, a tip here is because of the possibility of confusion, because you want to ensure that your mark and your application is successful, and you don't run into expensive legal problems once you file, it is wise to not go into this blind and just apply. We recommend that you do a clearance search, which will include a search of the Canadian Trademark Database, the register. It'll include a business name search, an internet search, domain names, and even just a simple Google search to see whether anyone is using the mark. In the case of my example, Derek Frenette Social Services, I would either ask Alexander Holburn or try to do that myself. Trying to do it myself, one can run into some trouble with that. It's always a good idea to start it and do some research yourself online to see what you can find. But beyond that, Alexander Holburn has a number of partner service providers that specialize in performing these types of searches and giving you a comprehensive report on what's out there and your chances of successful registration. Now, we've already talked about the concept of use. There it is in Section 4, in connection with wares, that you use them in the normal course of trade, and in connection with services that you've used or displayed them in the performance or the advertising of those services. And again, for our system in Canada, that is crucial to the system, and one has to prove use before A, they can register, and B, if it comes to it and you have registered, if it turns out you've registered by signing the statutory declaration saying, hey, I've used, and you haven't used, you're going to have a hard time enforcing that right, because when it comes time to send a cease and desist letter or approach a party that's infringing on your trademark rights and say, hey, I've got this trademark, the first question they'll ask if they're sophisticated or they have a lawyer is, show us. Where have you used it? When have you used it? How long? In what way? And we want to see. And in the case you haven't, and you've signed that statutory declaration nonetheless, you may run into problems, and that could actually lead to a cancellation of your trademark. As I said, the powers of a trademark are twofold. You can defend it against others who may say, hey, stop using the brand, stop using your mark because I have a similar mark. You would say, I have a registered trademark. Do you? How long have you used your services, etc.? It is a way to defend your use. And offensive, as we discussed, it's a way for you to stop others from using the same or similar brands. Strong trademarks are those which are unique. So I'll venture to say that my example of dog food in connection with clothing is probably pretty strong because it's unique. There's not a lot of people out there using it. Now, if I wanted to use a trademark like Ultra or Mega or Fine or any of those type of words in connection with clothing, that's going to be probably a weak trademark for a couple of reasons. I'm getting close to a trademark that describes quality or the type of goods I'm offering, and it's probably a crowded field. There might be a lot of folks out there who are using trademarks like Ultra or Mega in connection with their wares and services, even though they might not be the same as mine. However, a trademark that is unique in its field, and most importantly, trademarks that are completely unique or coined terms like Kleenex or Kodak, those are typically the strongest trademarks in the sense that there's nothing out there like them. They are completely unique. So I'll just close on that point by saying if you've already used the name in connection with your services and you've done so and you're kind of already established with that name, this might not apply to you, but in the event you have some control over what kind of trademark you're going to choose, the trademark you're going to try to register, it's always better to be unique, to be creative, and to try to have something that's different. Folks often want something that's going to fit in with the existing marketplace. So using an example, I think nonprofit services, it's a little tougher, but if we were to go back to a clothing example, you know, Ultras or Megas or Tailors or these type of common terms, they want something like that because it seems descriptive to them. It seems like it fits into the existing framework of clothing and the marketplace. But those are weak trademarks in the sense that there's greater chance that others are going to be able to challenge your right to them. It's going to be harder to register them as a result, whereas dog food or something that's completely different and doesn't exist on the register is going to be both easier to register and easier to defend and protect as a brand. So that is the presentation, and I hope I've answered a few more questions than I've raised. As I'm touching on these topics, we could keep going for a good long time, but I'm restricting this to about a half an hour, and I've probably exhausted your attention as it is. So thank you very much for that. If you have any questions,